good afternoon to all of you present here. I'm Pranjal Agarwal, a fourth year student at NLIU Bhopal. I'd like to welcome all the participants here, which is our viewers, and a distinguished panelist, Mr. Raj Panchmatia sir, Mr. Peshwan Jehangir sir, and Mr. Anindya Basarkod. Thank you so much for joining us here today. This webinar is hosted by SkillxPro in association with Khaitan Company and National Law Institute University Placement Coordination Committee. I'd like to briefly introduce our organizers, SkillxPro. SkillxPro is an online platform for skilling, upskilling, and getting placements for law students and young lawyers. SkillxPro brings to you courses that are curated and developed by industry experts and top-tier law firms to impart on-demand skills to help you bridge the gap between college education and profession. The courses are based on overall practice areas that ensures that the subscriber is appropriately skilled to specialize and work in that respective practice area. The subscribers shall also be mentored for recruitment process and interviews. And lastly, the subscribers are directly referred for internships and placements to top law firms and corporates. I would now like to introduce our distinguished panelist, Mr. Raj Panchmatia, sir. Mr. Raj Panchmatia is a partner in the dispute resolution practice group of Khaitan Company based out of Mumbai office. Mr. Panchmatia has rich experience in the field of dispute resolution and commercial litigation, both at the domestic and international fora. He has advised clients on a variety of claims under the Indian arbitration laws, CAC, LCIA, ICC, UNCITRAL, and HKAC, and has extensive experience in dealing with disputes under all forms of contracts and agreements. He is appointed on the CAC and HKAC panel of arbitrators and also advises clients on litigation before the Supreme Court of India, various high courts of the country, the Securities Appellate Tribunal, the National Company Law Tribunal, etc. He is one of Users Council, and he was instrumental in drafting of the Mumbai Center of International Arbitration Rules and is also a co-convener of Indian Arbitration Forum, Western Region. Mr. Panchmatia was also conferred the Rising Star Under 40 Award in 2016 by Legal Era. He is also a fellow of Malaysian Institute of Arbitrators. Thank you so much, Raj sir, for joining us today. It is truly an honor, and we are looking forward to your views on mediation and beyond.
It's a pleasure. Thank you.
Next, we have Mr. Peshwan Jehangir sir, who's a partner with the litigation and dispute resolution practice team. He has vast experience in the field of dispute resolution and has handled various international and domestic arbitrations and a large variety of litigation matters before a variety of courts in India, as well as the Securities Appellate Tribunal, the National Company Law Tribunal, Company Law Board, and National Green Tribunal as well. Apart from the various commercial and contractual disputes he has handled, he also has an extensive experience etc. Represented includes various leading multinationals and industrial houses in the country, including infrastructure companies, private equity firms, pharmaceutical, automobile, real estate, hospitality, advertising, public sector undertakings, and shipbuilding companies. Thank you so much, Peshwan sir, for taking time out of your busy schedule today and joining us here today.
You're most welcome. It's been a pleasure to be here.
Thank you, sir. I shall now introduce the third panelist of the day, Mr. Anindya Basarkod. Mr. Anindya is a senior associate in the dispute resolution practice group in the Mumbai office of Khaitan Company. He has experience in both commercial litigation and domestic and international arbitrations. He also has experience in institutional arbitrations under the rule of LCIA, DIFC, LICA, ICC, and ad hoc arbitration under the UNCITRAL rules of arbitration. Anindya's key practice areas are construction, FMCG, hospitality, infrastructure, and real estate sectors. He also has an LL.M from the MIDS Geneva and a brief internship experience with an international law firm in Frankfurt, Germany. Thank you, Anindya, for joining us today.
Most welcome, Pranjal. Thank you for the introduction, and thank you, SkillxPro, for inviting us.
It's indeed good fortune for all the students here to have three distinguished lawyers from one of the best dispute resolution team in India joining us. So thank you so much. I would now like to briefly elucidate the structure of the session. The structure is broadly divided into two sessions. First will be a discussion between the panelists on the topic resolving commercial disputes in a post-COVID-19 scenario. And the second session shall be a Q&A session on how to prepare for interviews in a post-COVID scenario and understanding the career path as a lawyer specializing in ADR. Here I shall be the moderator and shall put the questions of our viewers to the panelist. Before we start, there are some general house rules for this webinar. Firstly, all viewers are requested to place your mics on mute. Your questions shall be taken at the end of the first session, and you can share your questions in the chat section, which is given below in the app. And if due to paucity of time, we are unable to take all questions, we will revert separately later. And lastly, since we are all doing this remotely and working from our homes, there could be a case that we face a connection problem. Please bear with us in such a scenario and we shall fix it and be back very soon. We shall now start with session 1 of the webinar, which is on resolving commercial disputes in post-COVID-19 scenario. I would like to hand it over to Anindya sir to take the session forward.
Thank you, Pranjal. Thank you for setting the stage. Since Pranjal has already given an introduction to the topic and to the speakers, I'll just jump right in to the first question as to Raj sir. So what do you think are the available and alternate modes of commercial disputes generally and in the COVID-19 era?
I think, thank you, Anindya. Thank you, Pranjal and SkillxPro for having us here. So Anindya, taking your question, I think the alternate available to anybody and to any party who wants to resolve that dispute either during COVID period or prior to COVID period are virtually the same. It's only that how you want to go forward. I think today's time, all clients are under pressure, severe financial pressure. They don't want to spend their time litigating in court. They want to move on with their businesses, which have been hampered significantly in most cases. There is a lot of pressure on finances, bottom lines of a lot of companies. They are on the verge of collapsing. So I don't think any company or any client would want to litigate too much. Having said that, of course, your options are court litigation, arbitration, mediation, negotiation. And I think most clients would be more keen to either renegotiate their contracts, maybe bring some kind of a moratorium in their contract itself, try and see how they can commercially resolve those issues rather than going into litigation, because in today's time courts are not 100% functioning. Only urgent matters are being heard. So when there is an urgency, people are going to court, but other than that, none of your matters are moving that fast. Compared to that, yes, arbitration is the much quicker remedy if you want an adjudication process, or go for mediation, which can give you some kind of a resolution by parties agreeing to either rewrite a contract or mutually accept a settlement which is viable for both and both go home happy, and renegotiate your contracts for going forward. I think these are the very key things that are available. Of course, there are some hybrid models which are available internationally, which have yet to be tested in India, like the ARB protocol, which is of SIC, SIMC. But that's the only protocol that has ARB provision. So you start arbitration, go to mediation, and then take an award in the arbitration. Well, in India, that's not yet that popular, but I think it's a matter of time that we will see some hybrid models coming into India very soon.
Thank you, sir, for that. Peshwan, next question I'd like to ask you. Raj already mentioned that courts are moving to virtual hearing. There are, but mostly only for urgent matters. In that scenario, what are your views on the effectiveness of virtual courts? And do you feel that ODR has finally come to India? And what is the future of ODR in India?
Well, we are, to be honest, at a very nascent stage of this push to suddenly move things online. COVID came as a bombshell, and it has forced people to move onto the online platforms and trying to adopt. and change the ways they actually have been doing things historically. The issue in hand, what we do see regularly is that courts have been having considerable amounts of. Sorry, just a second. Sorry for that. So historically, courts have been inundated with a lot of hearings and backlogs. Very few things used to take place on the online platform. There were a couple of criminal litigations where certain courts used to hear bail matters, etc., on using online and video conferencing. But now we are seeing a drive where Supreme Court, High Courts are all adopting these technologies to move online. We've had a lot of teething problems with technology, and the adoption rate is we are moving along reasonably well. And I do see that in some time we will have a far better access to justice system on an online platform. It is far more convenient, it is far more cost effective, and there are some great benefits of having such kind of platforms available. But it will take some time to actually adopt through the length and breadth of India, because whilst we are seeing these technologies being adopted quite well and fast in the metros and the larger cities, India doesn't just contain the cities. There are a lot of remote areas where even electricity is a problem, let alone having a high-speed broadband internet connection. So to see this seep all the way down to the grassroots level is going to be a little bit of time. But it's definitely the way to go, and I see that there's a great future in this, and I see within a little time more and more courts will adopt, parties will adopt, not just for courts, but even in the alternative dispute resolution field. You'll see arbitrations are already moving into this far more efficiently and effectively. You will have mediations and conciliations having been run through online platforms as well. So this seems to be the way it is going to be in the future. And I do see that in the long run, parties will continue to use this platform once they've got used to it and the technology is being adopted by courts and the arbitrators are more familiar with them.
Considering that we've been in a lockdown for almost 4 months now, Peshwan, what has been your personal experience with, say, virtual court hearings in, say, the Bombay High Court or the Supreme Court, and also virtual hearings of arbitrations?
So in context of the Bombay High Court, Supreme Court, the Delhi High Court, the hearings have, whilst initially when they started off, they have tried, there were different platforms each court tried. They tried Zoom, they tried WebEx, they had a system called Video, which was used specifically because it's an NIC approved software. Each software has their own limitations, and initially the systems were not in place. So knowing when your matter was getting listed, being able to, the limitation on the sheer number of people being able to log onto the court for the court hearing. We had situations where counsels were not able to log on to for hearings initially. Because just everybody else whose matters were not even being taken up had already logged on and kind of maxed out the sheer number of people on the system. So the courts have evolved. They've learned that you have to let only a certain number of people in. So now they're also learning and evolving the systems and making sure it's becoming more and more seamless. Whilst the initial part of the lockdown, there was a lot more chaos, things have settled down quite well. We had an amazingly effective hearing from the Delhi High Court where we argued extensively both a Section 9 application for interim relief as well as an appeal. We've had multiple hearings before the NCLT for scheme matters and final hearings taking place in the NCLT in respect of that. It's been quite effective. And after the teething problems are over, fundamentally, a lot depends also on each individual lawyer's infrastructure as well. There are situations where counsels and certain lawyers tend to log in, say, using mobile phones and even like trying to log into a video conference using 4G and 3G. And then there are connectivity issues as well. So it's not always been completely seamless. But at the same point of time, there is certainly a push, and certainly this is going to be the way it is going to be. I see a great future for this, because sitting in Bombay, we've been able to have senior counsels based in Delhi come and argue matters in Bombay. We've attended multiple hearings in Delhi, sitting right at from the comfort of your home, and switch from a hearing in the Delhi High Court to a hearing in the Bombay High Court in a matter of a couple of seconds. So it has been great.
Thank you, Peshwan, for those personal views and what experiences you've had. We've also seen in 2018 the introduction of pre-institution mediation. Do you think this is something that is viable? What are your views? I'd like both of your views on this. Both of your views on pre-institution mediation, and do you think it's going to be a success, and what it would take for it to become a success?
Raj, you want to take this first, or do you want me to go?
Go ahead, no problem.
So, so statutes have certainly been amended, and the government clearly, government's mandate and intent seems to be very clear. They want to clear the backlog of cases pending in the judiciary. India has got a bad name because of the sheer number of cases which are pending, especially in the courts. The system has kind of jammed up because of the number of cases which are pending. So there is a certain push to ensure that ADRs become more and more popular. In that mode, they have, at least on the statute books, introduced pre-institution mediation in multiple legislations. Like you pointed out, the Commercial Courts Act, the CPC has provisions for mediation. Even pre-institution and post-institution, with consent, the parties can be sent. There's a Lok Adalat system which people are referred to off and on. Companies Acts have now provisions for mediation. The effectiveness of mediation or conciliation or any alternative dispute resolution fundamentally is going to depend on the efficacy of the person running the show. If you have a good mediator or a good arbitrator, the process can be, or a good arbitral institution which streamlines the entire process. It's a fantastic thing to see it in motion, because the processes can be streamlined and very, very efficiently managed. But on the other hand, we've also seen situations like, say, family courts having counseling sessions between people who want divorce. Those procedures are mandatorily to be followed, but still at that point of time, we find that effectively it's a checkbox approach where somebody goes into these counseling sessions and they attend once, twice, and a report is submitted saying that this is not working, and people ultimately still ending up getting divorced. So the effectiveness of this is really going to be with the person who runs the show, and see how effectively and efficiently they can. So the proof of the pudding is going to be in the implementation.
Raj, sir, your views on this?
See, I think mediation as a process is a very good starter for any organization or any dispute. So I think what courts are looking to do now as a pre-institution mediation is a good thing. A lot of this should be implemented in commercial disputes as well, which we've started to see. But it's a question of when and how quickly can we adapt to that. There are some teething issues which are coming in the way. But with a mediation act coming up very soon, a legislation to monitor mediation coming up very soon, I think those issues will also be taken care of. And I think it should be made in a manner that parties will have to necessarily first go for a mediation, say at least for 1 or 2 sessions before opting out if they don't want to go ahead. That's the Italian model of mediation, where parties are forced to go into mediation. In the sense, first of all, they need to go to mediation. If they are not happy within their first session or the second session, they have a right to get out of mediation. But as the status quo is mediation, and the otherwise is no mediation. So I think that will help resolve a lot of matters, because if you see, if parties actually go and sit in mediation for first session, and it's about, many a times it's about misunderstandings between the parties. It's understanding what each party's priorities are, and parties get to speak directly in, and they sit across on the table, which otherwise parties don't. When they have already started issuing notices and taken stands, they've already hardened their stands. They don't want to see eye to eye. But in the mediation process, I think they come to the table and talk. They get an opportunity to talk to each other. Mediator can, if a good mediator is there, he can facilitate this whole process, and that may actually resolve many disputes. So countries like Italy has had a very successful mediation regime, and I think India is also looking to see whether some part of it can be adapted. So therefore, now there is a move for mediation law. It also helps for enforcement of mediated settlement agreements, which was a big question mark in India earlier. But I think that's also going to now move very quickly, and we will have the law there. Again, in a pre-institution mediation, anyways, you can, once you have a settlement or an agreement in place, there are ways and means to enforce them, and the rules itself provide for the mechanism as to how to enforce them. So I think remediation is a very good option that parties should consider. And I think I don't see a reason why it should not succeed. It's only a matter of time that more and more parties start using it and implementing it.
Thank you, sir, for that. You already briefly touched upon the advantages of mediation, especially pre-mediation institution, one of which being that under the Commercial Courts Act, it is possible now to enforce a settlement agreement. Could you build upon, or could you go into a little bit more detail on the advantages of pre-institution mediation, and also go into the cons of pre-institution mediation? Again, if I would get, I could get the views of both of you on this, that would be great.
Sure. So, as I said, I think mediation as a process will evolve very soon, and I think it's at the cusp of going into the next level. Mediation has always existed in India from time immemorial. It is a process which has been primarily used in, say, family disputes, matrimonial disputes, some other smaller disputes. But I think the time has come that people need to use mediation more and more in commercial disputes as well. And we are seeing fruits of that. Recently, we did a webinar on mediation and how it can be used in the commercial dispute. I think what we heard from the experts there, it was really encouraging as to how mediation can be effectively be used in commercial disputes. I think the one effective part about it is that the cost in mediation is comparatively much lesser. So before parties go into and start spending more and more money in litigation, in arbitration, I think mediation can be very, very cost effective. And if you have a good mediator and if the parties are really inclined, the mediation can also resolve the disputes very, very quickly, and not go in for a long drawn process like litigation or an arbitration. One other advantage of mediation and enforcing those agreements is that you probably don't need to go and enforce it in court, because mediation is a process by which parties have voluntarily agreed and accepted certain positions and have decided to abide themselves by certain ground rules, and they have come to an agreement. So it's parties' consensual agreement that you are trying to look at, and parties are then required to honor their own commitments that they have made under the mediated settlement agreements. So you may not need to actually go to court to enforce it if parties are honest and are willing to implement those agreements in court. Of course, these are good things to have, and I really hope that parties do actually honor their commitments. But we've also seen in India that mediation has been used to delay the proceedings, to derail the whole process of litigation, because that gives them an automatic stay, or in some form, if there is already an injunction, parties may say, okay, now we will try and go for a mediation till such time, let the injunctions continue. Now that only extends the injunctions. So there are times when people have misused mediation. So therefore, it's very, very important to see how the mediator is able to control the disputes, or control the mediation, and how honest the parties are in mediation and in their efforts in mediation. I think that's very, very important. Uh, I think these are, according to me, are some of the important pros and cons in mediation.
Why, Raj, you're absolutely right in what you've said. I'll take from what he said. I'd also probably only thing I'd like to add is that mediation, conciliations are fundamentally parties renegotiating and coming to a mutual settlement. Uh, Courts would interpret a contract and then award damages or direct specific performances. You're not going to get much relief. The court will determine which party is more right than the other and award damages on the basis of whatever the legal principles are. The good part of mediation and conciliation is that a good mediator can bring the parties around to coming to a common ground and agreeing to something which may not be strictly on the basis of a contract and may go well beyond what the contract or the court may actually relief the court may actually grant. Because fundamentally, you could renegotiate contracts, you could extend the term of the contract, you could agree to deferred payment plans, and the flexibility under this process is just amazing, because it's and as Raj rightly put it, when parties renegotiate and come to a settlement of this nature, parties are more likely to voluntarily adhere to it. Otherwise, even after a dispute resolution process through arbitration or through the court process, you'll end up in appeal, an appeal from there, and you'll end up in the Supreme Court. And even at that point of time, even though the process of arbitration is over or the court process is you've got a judgment in your favor, the actual enforcement of the award or the final judgments is still several years away, and that's its own process. But in mediation or conciliation, if you enter into a settlement agreement, the chances of someone challenging it are very, very low. There is a lot more chances of people voluntarily adhering to it. And I find that the process itself is much smoother. So yeah, it's a great thing. The cons of this are exactly what Raj said, that if you don't have a good mediator, the chances of somebody trying to take advantage of the situation and just trying to delay an arbitration or delay a court process is very much there. And we've seen that in some matters where people say that let's take adjournments on the ground that we are talking settlement, and then actually nothing is really, there is no bona fide efforts by the parties to kind of resolve the issues. So there's a fine balancing act over there. But if parties' intent is clear, I think that this is it's a great option to have, and if it is used effectively, it's a great thing to be able to push through.
Thank you for that. If we can move back to what would now possibly say a little bit more orthodox way of resolving dispute, that is arbitrations. What do you feel are the pros and cons of arbitration? And do you feel that the pros and cons of arbitration have changed in this post-COVID-19 era?
So I think arbitration in India has suddenly taken a leap in India. I think people have suddenly started going to arbitration far more than going to court, especially in the COVID era, because they know that it is one, flexible. People are able to adapt to technology much faster there. They are listening the matters. The arbitrators are able to listen to the matters and give enough time in the for the arbitration. We are seeing actually increase in number of arbitrations that are taking place right now than they were taking earlier. People are willing to go to arbitration first, then go into courts. So I think there is suddenly a leap in the number of arbitrations that's taking place in India. I think what I also feel is parties still may be going for an immediate urgent relief under Section 9, because they need some kind of a protection, but then immediately moving to arbitration so that the matters can go on, which is something what people are looking for. We've also seen in arbitration, because of the restrictions that are now there under the Act, that a arbitrator can take only X number of disputes from a, say, a particular law firm, or he has to declare how many arbitrations he's doing. We've also seen a new generation of arbitrators coming up, and that's also opened up youngsters, young lawyers taking up arbitration as a career, and some of them have actually started sitting as arbitrators very, very regularly. So I think that's opened up a good pool of arbitrators, which is again a very, very interesting and a healthy development for the arbitration practice. And I think this is going to take us further to an arbitration bar or things like that. But of course, this is a very, very important step. Uh, the other thing that I see is also that people have started adapting to technology very fast in arbitration. Courts still had issues about which softwares to use. They have difficulty sometimes in getting many people. Not all courts are sitting on on a daily basis. We have selected hearings happening, whereas in arbitrations, parties are free to choose what technology to use. Arbitrators are willing to accept the technology, use of technology, and proceed. I think that's a very positive move, and I think arbitration therefore are going much faster and much speedier. Of course, the cons to that are going to be that one, it is a little more expensive than your court litigation. Second, after an award, what next? You're still going to get stuck in court. So that's another con that we have, that we may get a quick award from arbitration. So your step one is very quick, but you're then getting back stuck into the court process where there is a lot of delay. And with the present situation, the backlog is only going to increase. So we don't know when would you, even if you have an award, and unless parties by consent agree to resolve pay up under the award, you're still going to have challenges which are going to be in courts and will get stuck in the process. So there are certain flip sides to it, but by and large, I think uh, arbitration as an alternate dispute resolution has really picked up a lot. It's it's only a matter of time that presently we are 95% of our disputes in ad hoc arbitration domain. It's just a matter of time we need to move this to institutionalized arbitration to even streamline the process further. And that's where I think the challenge is. But I think it's definitely presently in present times to take out the burden from the courts. It's a very good alternate mechanism available. And I think we should encourage parties to go into either arbitration or mediation just to ease in the burdens of the court.
Peshwan, if I could get your views on this as well.
No, absolutely. I think that India, if you look at international contracts and which we've been entering into and seeing shareholders disputes, etc., most commercial contracts drafted for the past 10 years now have arbitration clauses as a standard clause within the contracts. It's clear that most commercial disputes are, I would say that majority of commercial disputes do land up being determined now by arbitration as compared to court processes. Yes, the court still stays involved in terms of supervision, interim relief, your 34s, etc. So you can't completely do away with the court, but at the same point of time, arbitration seems to be the preferred mechanism for determining these disputes. The great advantages of, say, cross-border enforceability as compared to, say, a foreign judgment which is passed by a foreign court being enforced in India is probably, there are only 16 countries which are notified under Section 44A of the CPC for reciprocal enforcement. But if you consider that the New York Convention has over 160 odd signatories, and out of which about 66 or 68 odd countries have been notified as reciprocal by the government for enforceability of cross-border awards. So there's a great advantage to that. It gives parties a lot more flexibility in terms of selecting institutions, selecting laws, selecting locations, selecting arbitrators who might very well be experts in the particular field in which the dispute is. So if you have an issue where it's more about accounts, you can select a chartered accountant to be an arbitrator. You need some issues where it's a construction dispute and certain things you might need an architect, you might need an engineer to be on the panel. So the flexibility which these alternative dispute mechanisms give to the parties is really, it has great advantages. But again, all these things, the arbitration is going to be only as good as the arbitrator or the institution which is driving the arbitration. So it's I agree with Raj that we've seen a lot of ad hoc arbitrations historically in India. And I do feel that going forward, the need of the hour is to push into having more efficient mechanisms of driving the arbitration procedure. And institutions seem to be able to do that a little better than individuals, because they have the backing of a secretariat, they have the ability to, or they've done this 1,000 times, so they are easy. They have tie-ups with say stenographers, with video conferencing. They are able to put that infrastructure in and assist the arbitrator in focusing on what he should be doing. He should be focusing not on administering the arbitration and the process and whether fees has come in or not come in. And he can just actually determine the dispute and focus on that, while the institution takes care of all the administrative tasks, or assist him considerably in taking care of the administrative tasks. So I feel that institutional arbitrations, and if you have a good institution, the process was a lot better, and that's pretty much where I see the things heading now.
Thank you, Raj. Thank you, Peshwan, for that. I completely agree that institutional arbitration is something that we need to give impetus to and really champion the cause. A lot of institutions like ICC and SIAC are also having conferences quite often in India to make that push. Moving to more from an external thing, more to an internal, I mean the role of the lawyer. What are we to do? Do you think the role of the lawyer has changed? Do you think the COVID-19 has had an impact on what should be the role of the lawyer? If I could get your insights on that, please.
So I'll tell you, the role of the lawyer generally is, and I would not restrict it to say pre-COVID or post-COVID in this. I think the role of a lawyer is to be very honest to his client, ensure that his ethical practices are being followed. Extremely important that the advice that you give to the client is a very honest and a practical advice. You do not need to encourage a client to go into litigation. It's not right. I think every lawyer has a duty to explain to the clients about the pros and cons of his matter, the strengths and weaknesses of his matter, educate the client about where he stands in his matter. Of course, the call is of the client whether he wants to go ahead or he doesn't want to go ahead. But as a lawyer, it is your duty to ensure that you tell him that either you will succeed or you may not succeed. But at the same time, also give him a first option to consider a settlement of the matter. Because I have always seen when you give a client a first option or a discussion to say whether you would want to consider resolving this through amicable discussions, more often than not, clients have accepted that position because they will see the cost of litigation, the time it takes. In India, it's possible that sometimes the litigations will go on for years and years and years. And therefore, it's important at some point in time to speak to your clients and advise them to consider resolving the dispute through settlement, negotiations, talks. It's very, very important. It's also possible that when the client comes to you for the first time, he's very angry at the other side. He doesn't want to listen about settlement. He doesn't want to talk to you about getting the resolution for him because he said, I am not interested. I've come to you. I want to fight. I want you to fight for me. You are my lawyer. How can you tell me to settle? This happens very often, and therefore you have to be very careful and give this suggestion when you think your client is receptive. Once the initial euphoria is over about filing, litigation, fighting with the other side, I think every client listens to you and tells, when you tell them that consider a settlement or a resolution of this matter rather than fighting this in court, and if you are able to get that for your client, he will be your client for life. So I think that's something that you should always be true and honest to your clients. Tell them where they are. I think it's also the duty to the court and to your firm where you are working.
Yes, like I agree with you, Raj. At the end of the day, it's important to act for a mirror, like a mirror, and tell the client what it is, because giving him honest and appropriate feedback at the right stage and not letting emotions drive the litigation process is very, very critical to arriving at logical or solution. Sometimes you see parties making bona fide efforts to resolve a matter, and one person, because his ego is pricked or he has a vendetta to kind of, or an axe to grind, the process is driven by emotion, ego, hurt, etc. So sometimes sometimes it almost feels like we are entering counseling sessions with your own clients, where you're trying to tell them factually that, look, this looks like a good offer, you might consider it. Things like that make a big difference in how litigation or arbitrations or resolution actually flows. Because if you tell the client that, look, this looks like a good offer, you're not going to get, you want 100 crores, but you're not going to get it because you don't have the data to back it up, or you don't have the evidence to show it. The client may consider the offer more practically and in a better manner, as compared to if you were saying, no, you'll get your 100 crores. So a lawyer's role to the client is to act as a good mirror and show him what the facts are, and be honest and clear with him as to what his case is and the strengths and weaknesses of his case are. Likewise, it is also dependent, the success or lack of success in litigation is also often determined by the choice of a lawyer, because his reputation, his skill in being able to be able to communicate and push his point across, his oratory and advocacy skills, his ability to be in a position to understand the mindset of a particular arbitrator or a judge, and put across the matter in a way which he's able to communicate that point effectively to the person who's sitting opposite him. And each arbitrator, each judge may have his own or her own mindset. So it's not a straitjacket formula where this is the law and you come and you throw 10 judgments and you're going to win the case, even if the law is in your favor. You will often find judges driven by equity, determining the matter, and in law there will always be gray areas and a lot of discretion which the judge has in which way to and what facts to state and how to make a matter fit the law. You'll find that if a judge is with you on equity, he may then try to mold the facts and mold the relief in a way where where the judge feels he's doing the right thing, and he will mold the law to assist you and assist the party who he feels has been wronged. And that's the role of your lawyer, because it's not just about knowing the law or knowing the facts. It's also being able to convince the person and convince the judge in a manner which is not really adversarial. You can't get up there and pick a fight with the lawyer. You can't. It's not about a shouting match. Oh, I've got the right judgment and this is right and you don't know anything. Nobody likes that kind of attitude in court. We've seen very, very effective lawyers being very, very humble and very, very soft-spoken and still driving the points home very, very effectively, often more effectively than lawyers who keep shouting in court. So you have your advocacy skills will have to come to the forefront. The role of a lawyer in the matter is huge when it comes down to the success or the non-success of your matter.
Thank you, Raj sir. Thank you, Peshwan. I think we have covered a wide range of topics. It's not easy to deal with practical issues and to deal with a bit of theory in less than 40 minutes, but I think we've managed that really well. With that, I would like to, this is pretty much the end of the first session, but we still have the second session left. That's career advice. And for that, I will hand over my moderating responsibilities to Pranjal. Pranjal, over to you.
Thank you so much, Anindya, Raj sir, and Peshwan sir, for your views. That was truly an enriching session, and it was really important for us to understand the practical aspects of mediation as a process. We shall now move on to session 2, but before that, I would like to tell it to our viewers that yes, we have been receiving a plethora of questions, and we shall take that at the end of session 2. Beginning with session 2 now, and which is a Q&A session with our distinguished panelists. And if I may draw you in, Raj sir, for the very first question, which we have. What are the major topics or concepts a law student should be aware of from an interview perspective, especially in light of the change in industry due to COVID-19?
See, thank you, Pranjal. I think the basic ground rules are that if you are deciding to go for litigation as a career option, you need to first have a clarity whether you want to go into counsel practice or you want to go into more of an advocate on record practice. There is a bit of a difference in both of that. But for both, I think some of the legal some of the laws that you definitely need to know are your basics, like a Code of Civil Procedure, Indian Evidence Act, Contract Act, Companies Act, and host of other acts as well. These are some of the basics, but the more specifics acts come into play when you choose which area you want to specialize in, because there are also specializations in various laws and various tribunals. So it also is very, very important as a student, once he gets out of the law school. Maybe for the first 2 years he may try his hands, or a few years he should try his hands at all laws. But thereafter, when he decides to say specialize, he needs to start mastering the subject where he wants to specialize. Because unless he specializes and masters himself in that subject, he will never be able to deliver that kind of advice.
Right, sir.
So it's very, very important that if he decides to go in for securities litigation, then he needs to know his SEBI and securities laws very, very well. If he decides to go in for insolvency practice, he needs to know his Insolvency Act thoroughly with the Companies Act. So these are basics that he needs to see. He's looking at practicing, say, in MERC or APTEL, where he needs to know his electricity laws well.
Right.
If he decides to go for consumer law, he needs to know his consumer law well. At the same time, these laws are absolutely necessary, but as a fundamental, as we say that there are procedural laws and then there are fundamental laws that you need to know. It's very important that when you are in law school, you really study them well, and thereafter also practically see the implementation of these laws. It's very, very important, because procedures will take you at a place. Beyond that, your fundamental laws, knowledge of that will be very, very important. And if you're practicing in, say, courts, you need to know the rules of the courts. You must know which court you are practicing. You must know the rules of that court, the procedures of that court extremely well. I think these things need to be completely understood by the students. Also, one more thing that I would say is that they should also consider, say, if they're going in for counsel practice or if they're going in for a law firm, they must also identify which practice areas they want to choose. If they're choosing a law firm, they also need to choose which law firm is doing what kind of work and what is their interest. And they need to choose the law firms accordingly. They need to choose the partners. They need to choose the seniors accordingly. If they want to go in for a counsel practice, they need to choose accordingly there as well, as to which counsel is doing what kind of matters, what are his specialities. So it's very, very important that they choose their law firms, their counsels, if they want to go into counsel practice, very, very carefully. Apply themselves, do some research when they are applying to what a practice is doing, and then go for it.
Thank you so much, sir, for your views. We had a follow-up question in the chat box regarding something you said, sir. How Aditya Goel from the fourth year has asked that how does a student decide whether he should go and become an arguing counsel or become a solicitor at a law firm? And once that decision is made, how do you approach that? If you could just share your views on that.
So today, I think we see most of the law schools making internships compulsory. This is the time when they need to understand what they are doing. So do your litigation internships, do your internships with counsels. You will see both sides of the story. Also, see how good an orator you are, how quickly you can argue, how well you can argue, how well you can convince. Because see, everybody may not be trained to be a counsel, or everybody may not have the inherent talent of being a counsel, or some of them may have, or some of them may feel that acting as an advocate on record or a solicitor is not their cup of tea, and so they would like to go and argue the matters because they feel that they can do a better job there. Then, by all means, but that's something that when you are doing your internships, test it out. You may not get an opportunity to go and argue in court, but you will be in court with the counsels, with your seniors, observe, see what you are doing, whether you want to go into counsel practice or whether you want to go into court practice in a solicitor's practice. I think both have very different roles, but they're very, very important, and one can't go on without the other, to my mind. Of course, there are lawyers who also argue and also do advocate on record practice, no doubt about it, and they're very successful ones as well. But I think a good mix of both is very, very important. So therefore, and it's not that if you're working in a law firm, you can't argue. Of course, you can argue. Every law firm encourages its juniors to go and argue the matters. So we definitely encourage for the youngsters to go and argue the matters. It's only when the matters stakes are very high, when the clients insist on engaging a counsel, that the counsels are brought in. So it's a very important balance that they need to do when they're doing their internships. I think that's the most important thing.
Yes, sir. Thank you so much, sir, for your valuable insights on this question. If I may now draw you in, Peshwan, sir, for the second question which we have. What are the do's and don'ts for a law student who's looking to build a career in litigation and in ADR?
So I think that too many law students come into the profession thinking that litigation is going to be like the movies. They've seen heroics, they've seen all your suits, and they've come into litigation with blinkers on their eyes without really realizing what the profession is going to be like. Okay, it's not all about the fame and the glory and pulling out that magical case law. It's a matter of litigation is a profession where there's just no substitute to hard work and getting your hands dirty. Okay, it's very frustrating at times because yes, a lot of times courts matters get adjourned. A lot of time is spent waiting around for your matter to come up. You often go to court very well prepared. You've got all you're ready to argue. Your side is ready to argue. The matter gets adjourned. It can be very frustrating. You might argue a matter on a point which you think is a brilliant point and sure to win, and the judge may consider some other points and rule against you. Okay. So there is a lot of ups and downs and emotional turmoils which we find people coming into the profession face, and then often they get disillusioned and tend to move away after a while. I feel that it's important for you to be aware of how the Indian judicial system works and how arbitrations work before you get into and choose this profession. Okay, so I would say that one is keep your mind open and do internships with, if you want to do make a career in litigation and disputes, join a counsel, come to a litigating, see the processes before you make this decision, and approach it with your eyes open. Okay, that's the first thing I would say. Apart from that, you need to be, as Raj had rightly pointed out, as a litigator, you will be faced with multiple facets, multiple laws. Today in litigation, I might be doing one infrastructure arbitrations, another, it might be another writ petition because under for willful defaulters, it might be something got to do with a PIL. Each matter has its own nuances, and you will be forced to study multiple laws and multiple. You might come up with a shareholders dispute, so you might need to have experience in the or study the Companies Act more in detail. So you can't really prepare on the substantive laws, all the substantive laws which you might face in your career. But it's a great place to be because you get to see everything. You might have to you will learn about the pharma industry if you're doing one matter about pharmaceuticals. You will learn about the infrastructure and how a metro is built if you're doing a arbitration pertaining to metro construction. So it's a great thing in context of ability to learn and learn to think on your feet, because you will be put into situations where you will be caught aware. You might be very well prepared in, or at least what you will consider to be very well prepared for a litigation, and the other side or the judge will throw a googly at you which you have not anticipated. Because litigation is like a game of chess. You move, the other side also moves. And it's not like a negotiation of a contract where you can say, hey, let's park this issue, we'll come back to you later. Often judges will not let you do that, and they will push you and determine the matter once your hearing has started. So it's not possible to be in court and say, hey, hang on, I am not prepared on this point, we'll consider this point, let me address you on this point on another day. The court may not allow it and may pass a ruling. So you need to be extremely thorough with your brief. You need to be very well aware and anticipate what the other side and the judge's mindset is going to be like and what questions may come from that. And I think that's going to be the core skill set of a litigator. Your ability to anticipate, read the court, understand the matter and its nuances. So you have to approach it with that. Of course, you need to know your procedures inside out. Okay, because each matter, your focus before you come in, you have to know your Arbitration Act, you have to know all your CPC, CRPC, your evidence. Those are your just basics which you need to do. Each court has its own set of rules. If you're going to practice in Bombay High Court has its own set of original side, civil, appellate side rules. If you're practicing in city civil courts, they will have their own rules. If you practice in magistrates courts, they have pretty much each magistrate will have his own procedure. When the matters are taken, when interim applications are taken, when final hearings are taken. So you will have to learn on the job. Okay, don't come into court thinking that, don't join the profession thinking that, hey, I come from a national law school and I've come first and I'm first class, so now I'm going to be able to be a great litigator. That's not how it works in reality. The reality is that once you join the profession, there's a lot of skills which you learn in practice, and only when you're in court. The ability to convince a judge or communicate, or what kind of application, how to draft, what to say, what not to say, when to stop talking. These are skills which you learn only when you're in court, when you're when you do practice. You need to be interning with more litigators to see this and start picking up nuances. Court right now, there are a lot of virtual hearings. Maybe you guys can log on to some of these on days on which you've got free time. If you are post-COVID and court physical hearings start opening up, please attend court, sit through days of court, lots of counsel. You'll learn lots of nuances, see how the judges react, see how the system actually works. You might hear some fantastic arguments by seniors who you would never be able to really, you may not work with them, but you may still learn and pick up a lot of skill sets and understand the laws a lot better when you hear arguments. So my advice is to start working, intern, get out there, get your hands dirty. There's just no way of getting out of that.
Okay, sir.
And it's a lot of
Thank
hard
you.
work. Yeah.
Thank you so much, sir. That in fact was a very encouraging answer on litigation and ADR as an industry which young lawyers can join. Our next question is for you, Raj, sir. Do you think COVID-19 will have a long-term impact on ADR and careers in ADR?
So I don't think COVID-19 will have any major impact for careers in area. The only thing that is happening presently is probably your learning curve has slowed down a little bit, in the sense that if you were a lawyer and if you were doing litigation, you learn a lot, as Peshwan rightly said, by going to court, observing the arguments, observing the counsels, the different kinds of arguments that are being taken up on a daily basis, what you should do, what you should not do in a court hearing. You learn a lot when you are in court. I think that is something that has slowed down right now. So the learning curve has slowed down, but it's not stopped. It's a matter of time that when the online hearings will be made available to public where anybody and everybody can join, that will probably help to get back that learning curve. But I think overall, I don't see there is any setback because of the COVID. Yes, the recruitments may slow down a little bit for a while, because the situation is such. Everybody is looking at slowing down a little bit, but I don't see that this will remain permanently. If once we are out of this unusual situation and abnormal situation that we are in today, and if things start recovering faster, I think everything else will start picking up again. So there may be a bit of a setback, but it's not that it is a complete setback. It may be a slowdown, I would say, not even a setback.
Okay, sir. Thank you so much, sir. We had a follow-up question regarding the same point on the industry outlook of dispute resolution. The question is, given that most dispute resolution teams and even councils in India do not exclusively do arbitration, will India ever have a specialized arbitration or mediation industry like other countries?
I think I'm very positive about it. I have been a very vocal supporter of that. So I think I do see an arbitration bar and a mediation kind of a group that will be there permanently very soon. It's just a matter of mindset. It's because there are not many people who are focusing only on arbitration. We're seeing this. I think in India the situation is that you also can't say that I'm going to be doing only arbitration, and if you don't have enough arbitration, what else do you do? So it also depends on how much work you
Right,
have.
sir.
So presently in India the situation is that we've not reached that stage, but we will reach that stage very soon. Internationally that has happened because there are enough arbitrations for a particular team or a lawyer to continue doing arbitrations. In India, you need to be able to have so many arbitrations for a party, for a lawyer to say that I will only practice in arbitration or a mediation and not go to court. We need to build that skills. When we get new set of arbitrators, we will also get new set of lawyers who want to continue doing only arbitrations and not going for court litigation. We are seeing that trend. Not many law firms today are doing that in India because, as I said, you need enough work in that space. If you don't have enough work in that space, you can't say that I'm only going to do arbitration. And the day you don't have arbitrations, you can't be sitting and doing nothing, right? So it's just a matter of time. But I think India has to move towards creating a specialized arbitration bar so that we have lawyers who are not practicing arbitration as a secondary job. like post 5 o'clock. We want them to come into the mainstream, doing full-fledged arbitrations from morning till evening, spending good time in arbitration. We need arbitrators who are willing to take that up, take that job, doing arbitration from 9 to 5. I think it is a good support mechanism to courts. It is a good substitute for the court. You are actually, if you have a good arbitration bar and a good set of arbitrators, you're going to reduce the backlogs in the court, and you're going to have a parallel dispute adjudication system, which will only move disputes much faster. So I think it's a matter of time we will get a good arbitration bar. I just wanted to mention that at IAF, which we are working on, our whole objective and aim is to create an arbitration bar in future. So as an Indian Arbitration Forum, that is our one of the biggest objective.
Right, sir. Thank you so much, sir, for your opinion on the same. For the next question, Peshwan sir, if I may draw you in, the question being, how effective have virtual court hearings been? And also, would your answer change for virtual/online mediation, since apart from verbal and on-document arguments, even non-verbal cues might be a relevant factor in mediation?
Sure. So, two things. Whilst the infrastructure is still developing, especially for courts, and as I mentioned, there were a lot of connectivity issues and infrastructure issues at the initial stages. I find that now, at least the Bombay High Court, Delhi High Court, Supreme Court, they've adopted reasonably well, and the systems have evolved to a point where they seem to be working much better and far more seamlessly. Yes, there are still issues in context of connectivity. Sometimes there's someone's internet connectivity, even if it's broadband does fall, and there are connectivity issues where you can't hear. But those issues are becoming less and less as we are progressing. I find that the judges are also, it's not that they are not able to comprehend and cope. You must understand that I find that the younger judges are coping with technology far better than the very senior ones, especially if it is digitalized copies of pleadings, etc., being emailed. The younger guys are able to sort of deal with the PDFs and the bookmarking far better than somebody who's 60 years old or a retired arbitrator. There are issues. There are senior counsels who have adopted to being able to appear using just PDFs extremely well. There are some people who are still struggling with the technology. It's like asking your dad that, can you handle everything on a PDF, and versus you being able to handle something on a PDF. The skill sets are different. People have grown accustomed to a particular manner of functioning. Okay, so it will take some time for efficiencies to come in. But I don't see this being as a hurdle in the long run, because people will learn. If they've done it a couple of times or they're forced to do it a couple of times, the fourth, fifth time becomes easier and will become more and more routine. And you will be in a position to have far more detailed and lengthy arguments on virtual hearings. I find that virtual hearings, at least so far, the courts themselves have been far more patient because of the sheer number of matters they normally list in a day. Like in a physical hearing, courts were listening sometimes 40, 50 matters in a day listed. So you would get very few minutes to convince the judge on your case, and he would throw you out or give relief. So your time spans were shorter. In the COVID times, people are hearing maybe 12, 15, sometimes 20 matters a day. So the number of cases a particular bench is listening to is limited. So he's giving you a far more patient hearing. It also means that counsels need to be prepared far more in detail before they present their case. Because in court, often you would have a counsel who's arguing a matter along with a solicitor standing next to him, and like who can peep in and give him advice saying, point this out, show him this judgment, or show him that if he's missed something. But if everybody's sitting in different locations, those are issues where I'm sending a WhatsApp to the arguing counsel saying that consider this point and show him paragraph so and so, and he has to look at his phone. So the processes are different. Okay, but it's happening, and it's not something which is impossible to surmount. But the way we function, the way we prepare for matters is changing. And we are in a state of flux where I feel that the people who learn to adopt this technology and change with the times will be the ones who will be able to cope with the pandemic far better and come out victorious and far better than the people who stay old school and say, I am not going to learn how to do a video conferencing. It's just not possible to do that anymore. We have to wake up to the realities. Uh, I feel that if this technology works for the next few months, there's no reason why it can't work continuously beyond that. Once you've seen that this is an efficient system and it's working, service using emails. Bombay High Court has just come out as of today rules that service by emails, and the Supreme Court has even now allowed WhatsApp services, etc. So the time has come for adopting change, adopting online technology. We will move with the times, and we will be forced to in some ways. But it's here to stay. We are not going to go back to pre-COVID times where things are going to go back to only physical hearings. I see that this is the way the future is going to go. Not all hearings are going to go on online. I don't think that you can do away with physical hearings completely at this point, because technology is not reached that level. There will be smaller courts, smaller matters, which may not be able to adopt this technology permanently, and may have far more issues in smaller cities and smaller towns where courts are. But maybe somewhere you'll land up with a hybrid model where certain kinds of matters are done online and certain matters are done physical hearings, and you might have options available to lawyers to determine which kind of matters and when they want to argue what kind of applications. So I feel that we will learn, we'll land with our feet on the ground as we move along.
Okay.
I would say that one challenging aspect I would put for everybody is that cross-examinations are still little difficult to conduct using an online platform, because cross-examinations, one is you need to be aware that the witness is not being prepped. You want to make sure that the witness is not referring to some notes or somebody's sending him WhatsApp text and giving him answers and feeding him what he needs to answer.
Yes.
There are issues with online cross-examination and evidence being taken. In the past, when we've done it on a couple of international arbitrations, etc. But normally what you would do is, if you are cross-examining the other side's witness, a representative from your side would be present in the same room as the witness you're cross-examining, to make sure that he is looking only at the brief and he's not made his own notes, so nobody is like giving him answers on another screen. Things like that in the present COVID situation, where nobody can actually travel to the witness's residence or an office, etc., and social distancing, those are challenging. But we will evolve to a point. Maybe if you have 2 or 3 different cameras in that room, maybe you'll be able to manage to do that virtually. It's a matter of time and how the technology you adopt and the flexibility you show in kind of making sure this moves along.
Thank you so much for such a detailed answer. That was really insightful. Next, if I may draw you in, Anindya, for the next question, which many of them have been asking in the chat section as well, which is that interns in Khaitan and company are operating virtually, or as we call it, virtual internships are happening. What's your feedback on the same? And do you think that an intern may have a disadvantage in terms of getting access and receiving a PPO by the fact that he's doing a virtual internship, he or she is doing a virtual internship and not a physical internship?
Thank you, Pranjal. Perhaps I may not be the best person to respond on the PPO aspect, but I can definitely respond on what has been my experience with interns doing it virtually. We've already had about 2 batches of interns. Yes, I would say they're probably not getting the 100% of work that they would have got, but it's much better than one would have thought. I mean, I have been interacting with some interns, giving them work. So a lot of my teammates and seniors. I would think they would be functioning at about 80-85% of what they would have been done in a physical internship. To give you an example, we're doing an arbitration. I can't go into specifics, but we've been requesting research from them, research notes from them, and I don't think that that would have been any different in a physical internship or a face-to-face in-person internship. So I would say it's a lot similar to a physical internship, but obviously in the long term, it cannot replace a physical internship.
Okay. Okay. So thank you so much, Anindya, for that answer. Our next question is for Raj sir, and this is from one of the questions we have received in the chat box section. How has COVID-19 affected the hiring process of dispute resolution teams across the country? And once the lockdown is lifted, is there expected to be a rise in volume of work and employment opportunities? So is there hope for that?
So I'll tell you, disputes as we presently forecast are likely to only increase post the lockdown comes to an end. Today also the dispute practice in most of the law firm are quite busy. I think most of them are really flooded with work. Of course, we would have preferred if the lockdowns were not there, we could do much more. But having said that, it's the dispute practice in most of the firms are busy. So I don't see that as an issue. I think in the long term, the recruitment process will come back to its normal. There may be a bit of a postponement of a lot of issues, but at this stage, but that's probably so in most cases because everybody is looking to stabilize again after the sudden impact of COVID that has hit the industry and across every litigation practice. So I think there may be a bit of a slowdown, but I don't see that as a stop in the process. It's only a matter of time that it will pick up, and the picking up will be also very fast. And I don't see that people are not recruiting completely. If there is a need, if there is a requirement, firms are still recruiting. So it's not the case. In fact, as of Khaitan has also ensured that all the freshers who are joining will be joining the firm. So we've not cancelled anyone's joining. So in that sense, you will see that firms like ours and there are others as well who will honor their commitments and they will recruit when the need arises. And I think if there is a need and if there is a requirement, there will be recruitments. But to say that continuously there's going to be a recruitment like it used to be earlier when the physical activities were very much on, presently it's very difficult to see that.
Right. So thank you so much. That would really help our viewers understand the situation better. Thank you so much for clarifying that. Next up, if I may draw you in, Peshwan sir, there's a question from Syamantak Sen from the third year, which is that we have been hearing that there will be an increase in post-COVID disputes. To get a real-time update, have you seen such disputes increasing? And if yes, in what kind of numbers, if you could share with us?
So putting numbers is a little difficult, okay? But let me put it to you like this. We are seeing a lot of advisory work on, say, force majeure, frustration of contracts coming in, which is unique to the present times, okay? But let's face it, people always litigate. They may want to avoid it, but some of the situation it comes to a point where often disputes are unavoidable. Some parties take very strong positions, and ultimately you land up in court, arbitrations, etc. The sheer number of cases which are pending in the high courts and the courts in India are evidence of that. Okay, so litigation is not going to go away. The certain kinds of litigation and the kind of nuances to which you may have to deal with. Say the force majeure clauses in contracts have now become of prime importance. People are looking at them far more in detail as compared to boilerplate clauses which have been put in historically. Often force majeure clauses did not cover the concept of a pandemic or a epidemic within the concept of the force majeure clause. Now, force majeure is something which is contractually enforced, and it depends on how well the force majeure clause is defined in the contract, and that will depend on whether the party has an out or can claim it or not claim benefits of that clause. So what you look at a relevant time, and right now, yes, force majeure frustration seems to be the flavor. We are giving multiple opinions on this. There is They are making applications for extension of time, etc. of these kind of contracts. But post this, a lot of authorities have taken very pragmatic views and have also said that yes, irrespective of what the clause says, I will agree that this is a force majeure, and I don't think that I want to enter into litigation with you, and I'm going to give you an extension of time. There might be some side litigation on cost escalations, etc., which may or may not get completely resolved. But we are also finding that there are a lot of parties who have been thrown into the COVID situation are trying to be pragmatic in trying to avoid litigation so that they can get back doing the core business. So a lot depends on the relationships the parties share. Before the COVID lockdown, if everything was smooth, people are still looking to get back to commercials and resolving the matter amicably, as compared to if your relationships were already strained, now you want to fight, now you've got the excuse to fight because there has been some kind of technical defaults on the documents. So it'll span out. I don't see that there's going to be a sudden spurt of litigations all over the park. I feel that, but there will be a lot of people have not initiated litigations during this period because courts have very limited functionings. NCLT was not allowing filings of certain kind of proceedings till quite recently. There have been high courts which have allowed only urgent matters to be emailed and filed. So you'll find the backlog of litigations which have been prepared and not filed. You'll find a spurt of that. But overall, I don't think that suddenly everyone's just going to be fighting all the time.
Right, sir. So thank you so much for sharing your views on the same. Anindya, if I may draw you in, for young lawyers in India, what are the do's and don'ts in the ADR sector?
Thanks, Pranjal. That is a very wide question, but I will try to limit on a few things that I think are important. One is the question of your skills. As a junior lawyer, I would feel that your most important skills would be drafting and research. And drafting is something that is, of course, a continuous process. I, myself, at my level, cannot claim to have excellent drafting. So it is, how do you say, it's a life of improvement. You have to keep improving it over your lifetime. But these two skills, I think, especially, are something that junior lawyers must keep in mind. And that is, I think, the greatest asset of a junior lawyer to the larger team. Another thing that I think gets overlooked a lot is communication. It's not always going to be that what instructions you're getting are clear. You may have doubts. I think it's very important for junior lawyers to communicate any doubts that they have to their teammates, their seniors, the partners, and get clear instructions on what they're supposed to do. This, of course, saves time later because you don't have to keep redoing things. So you can get it perfect or you can get it right just at the first go. And now moving from skills to just my views on arbitration and the outlook that junior lawyers have towards arbitration. Compared to when I graduated in 2011, I see a lot of junior lawyers, a lot of freshers, very interested in arbitration. That's very heartening. Yes, absolutely, it's a good thing. But ultimately, we have to keep in mind that arbitration is procedure. Mediation is procedure. You may be perfect in procedure. That's great. That's a great asset. That's a great skill to have. But don't lose focus of your substantive laws. You need to know your Contract Act. You need to know your Companies Act. You need to know, if you're doing a dispute regarding construction or you're doing a court litigation regarding land laws, you need to be well versed in that as well. So though you are well versed in your procedure, don't lose sight of the substantive laws. The last thing that I want to touch upon, and this is a question I see already in the chat box, is of LLMs. I did an LLM after 5 years of work experience. I think for me that was the right time because I knew exactly what I wanted to do. So one thing I would say, don't rush into an LLM. Know exactly why you want to do that LLM, what you want to achieve out of the LLM. Personally, I knew that I wanted to do a master's in arbitration. I applied only to that university or that course where I wanted to go. So don't be in a rush to jump into masters right outside you right out of coming from college. I don't think that's going to be a lot of value to you because ultimately you're spending a lot of money. You're doing a general master's, may not really have much impact in your career, may not really benefit you a lot, but get a bit of work experience. And actually a lot of master programs value your experience more than sometimes your marks as well. Marks of course matter, but experience also adds a lot to your CV. So get some experience, know exactly why you want to do the masters, know what masters you want to do, and what you want to get out of it. And I'm telling you, like from personal experience, I think the masters I did has changed the way that I think. And if you're doing a master's, try to see if you can get an internship, because you learn how things are done abroad. You can get their best practices back to India as well. So again, summarize, masters are good, but know exactly why you're doing it, what you want from it, and do it after you have some work experience.
Thank you. Thank you so much, Anindya, for that really insightful answer. We have been seeing that question in the chat box often now. Thank you for that. Raj sir, if I may draw you in now. The question here is asked by Janak Pradhan from the 4th year, which is that there's a general feeling amongst law students that law firms hire less for the dispute resolution team compared to the corporate vertical. So considering that is true, assuming that is true, and if that's not, you may say so. Considering that the competition is also more difficult, so is there something specific which you expect in an intern in the dispute resolution practice?
So let me put it this way, it depends upon firm to firm. If a firm is a corporate dominant firm, they will probably look for more corporate interns, corporate lawyers. If the firm is a dispute dominant firm, they will look for the dispute lawyers. If there is a good mix, they will definitely look for both. So it is very specific to the firms that we're talking about. So it's not there's a less recruitment for litigation or a bigger recruitment for litigation, because I know when I joined the firm, the Bombay practice had say around 3 associates in litigation. Today we have 55 associates in litigation. So the number of people who have joined litigation practice over the years has been phenomenal. So we've had a great practice growth. So it's not that we recruit less for litigation, but yes, of course, there is a very clear lookout for a good quality. And we look for some of the best minds in the dispute side that would want to join, because we're seeing that a lot of people want to go into corporate, or some of them want to come to litigation and then move to corporate. So we also don't want people who are not that serious about disputes or litigation. So people who are, if you're looking for someone, say, to join disputes practice, or anybody who's looking to join someone in the disputes practice, you have to be very serious about the disputes practice. They ought to have shown their interest through their CVs and through their internships, that they have been always interested in doing their dispute practice. Of course, I'm not saying that we've seen some of the great corporate lawyers turn into a good litigators. We've had instances where we have had corporate lawyers who have then decided to change track and be dispute lawyers. For instance, Peshwan, he was a corporate lawyer to start with. He moved into a dispute practice. So I think we've seen some great changes there also. So of course, that's also possible to change field, but then that interest has to be there. You must have the liking, you must have the calling for doing litigation. Unless it's that interest is there, you will never be able to do justice to what you're doing. So I think one, ability to work hard and willingness to work hard, because disputes is not a practice where you can sit on your table and do your work. You need to really dirty your hands. You need to be willing to do all kinds of work. There is no work which you can say that is below my dignity or I will not do it. Nobody expects you to do something which the others have not done, for sure. But at the same time, you need to work hard. No work is small. All work is good. You must have the appetite to work hard. You will learn various different laws in disputes. As Peshwan had also said it in the past, that when a matter comes to you, you may have matters from varied laws, different laws. Each matter will be different law. So your exposure to law is very, very different. You will see how the laws are being interpreted, how they are being applied. So of course there is a far more detailed learning in that. But you should have the willingness to put in that extra effort, the hard work that goes behind it. Because unless you're willing to put in that hard work, disputes, you will find that you are grappling in dispute practice. Honestly, I think that's the only thing that I can say.
Thank you so much, sir, for that reality check for everyone here.
No, on a lighter note, I agreed with everything with Raj said, save and except one, which has been proved wrong by the COVID times, that you can't do everything sitting on your desk. Now, literally, that's exactly what we've been doing over the last 3 to 4 months. But he's absolutely right about it. You have to get involved and completely with the matters and get your hands dirty. There's just no way around this at all.
Right, sir. Thank you so much, Peshwan sir and Raj sir, for your views on this question. Peshwan sir, if I may draw you in on this question, which we have received in the chat box section, is it that do you anticipate a change in the type of questions during interview for internships / recruitment since COVID has happened?
Sorry, Pranjal, I couldn't hear you very clear. Hello?
But also,
Pranjal, sorry,
Your voice.
I cannot hear you. Your voice is cracking.
can you hear me now? Am I audible now?
Yes, now you are.
Apologies for that. If I may repeat the question, so this is something we have received in the chat box section, that how will COVID affect the change in interview questions? Is it that, like earlier what we had an idea, is that it is CV related and from what you have done at your internship, so questions would be restricted to that. However, since COVID has happened, how does that affect a change in an interview process?
Well, I don't know whether there would be a major change in the interview questions. Okay. I would still push to understand more from experiences you've had as during your internship, etc., and the skill sets available to you. I would push for that still. Apart from that, I also tend to look into a person's extracurricular activities and see what they do beyond just their academics. Because I find that, especially from a law firm perspective, it is a lot more to do with team play. There's a lot of interplay between people. You are often under a lot of pressure with work, so the manner in which you deal with people is going to be very, very critical. Sometimes you have brilliant lawyers but they are just too individualistic to be, and they disrupt the team. And sometimes that has far more negative impact on the ability of the team to perform than anything else. So it's a fine balance, and it's not just when we at a law firm, when you hire, you don't look just at one aspect. You look for a whole package, right? You want somebody who is obviously well prepared and has the educational qualifications and as well. So you do look at the technical aspects, but you will also test him for his ability to communicate, his ability to write, his ability to deal with the other people and deal with the stress and emotions involved with this. So I would still look for that. The core elements do not change just because of COVID. So I don't think you'll see a major change in interview patterns. Maybe you'll have an online interview instead of a physical interview, but I don't think my line of questioning would change.
Right, sir. Thank you so much for clarifying that, sir. That would have been really insightful for all our student viewers here. Raj, sir, if I may draw you in for this question, which we have received from Samantak Sen from the third year. Given that India has not ratified the Singapore Mediation Convention yet, will there be any enforcement concerns, including time concerns, with regard to enforcement of a settlement reached through mediation?
So the Singapore Mediation Settlement Convention is more for the cross-border mediations to be enforced. And while we have not yet signed the enforcement agreement, reciprocating agreement, but we are the signatories also to the Singapore Mediation Convention. So it's a matter of time that we will sign that as well. It's just, I think it's just got slowed down the process because of the COVID, but I think India will sooner or later do that. So maybe in the short run, we may see some difficulties, but I think in the long run, it's a good process. Having already recognized the convention, I think it's only a matter of time when we will ratify it in India as well.
Right, sir. Thank you so much, sir, for your views. And this is our last question for the day, and this is for all the three panelists here. Is there any general advice you would want to give to the student community? Any feedback? It could be some suggestion on how we look at our career, or some experience which you would like to share with our viewers here, which taught you something. And we would love to have views of all our panelists here on this question. I would request Raj sir to go first.
So let me put it this way. I think at law school, at least I was not sure what I wanted to do. So I jumped into the whole thing after I finished my law, and I had done no internships, honestly. And I have come through the grind through various law firms and eventually at Khaitan. So I can understand there may be a lot of confusion, but during my times also the lack of information was also a case. Maybe I was not aware. It's possible it was there, but I was not aware, or I was not that inquisitive about finding it out. But I think today's generation, the youngsters have a lot more information available to them. The colleges insist on internships. I think these are good good learning curves, and this is a good time to know what you like, find out your likings, where your heart is. Do something where your heart is. Don't just jump into it because your friend is doing it, or because you've heard that it is very glamorous. It may not be that glamorous as you think it is. The glamour comes when you reach success, but but it's a long way before that. And I think it's a lot of hard work in the bargain, a lot of efforts. And I always tell all my juniors that I like the sayings of army, which say that the less you the more you sweat in peace, the less you bleed in war. So put your hard work, spend a lot of time, lot of efforts, lot of energy in what you want to do, and once you've chosen it, do it with all honesty. Be true to yourself, that what you're doing and where you're putting your heart and you're doing your efforts are 100%. I think once you put your 100% effort, I'm sure there is no looking back and you will succeed. I think go for it. If you have the inclination for litigation or arbitrations, generally either as a counsel or as a law firm, but choose it wisely and then go for it.
Peshwan sir, if we could have your views on the same.
So look, I was never interested in law as a career. Okay. I did my graduation in science. I wanted to do genetics, but I never wanted to go abroad. And then ultimately it fizzled down to saying that if I will go abroad and study genetics, I have to come back and take up a job over here. What's the point? I'm never even going to recover the cost which I spend on my studies. So it came to a point where after my graduation, for 3 years, I did nothing but hike and camp, and I ran expeditions to the Himalayas and camps, and ran a program called the Duke of Edinburgh's Award Program in 60 schools, taking young children out on doing outdoor activities. And then, yes, it came to a point where I said, okay, I have to think of some long-term career as well, I have to make money. And in my wisdom or lack of it, I came down to two professions as choices. I said I can either teach or I can become a lawyer, because if I teach, I'll get Diwali, I'll get Christmas, I'll get summer vacations where I can go out and hike and trek. So I walked to law school and I said, these are my marks in my BSc. Do you think I can get admission? And the lady at the counter said, yes, tomorrow is the last day. Fill in this form and pay your fees. And I did. And if you had asked me maybe 4 or 5 months before I joined law school that you will be a lawyer, I would have probably laughed, because the thought hadn't even crossed my mind. Okay. But two things did take place once I joined law school. One is I made a commitment to myself saying that, look, if I'm going to do this, I'm going to do this properly and I'm going to give it my all. Okay. Second thing which I found is that I enjoyed it because in this profession, it's you're living it. It's not that you come home at the after office and you can cut off from your matters completely. Often the best thoughts and ideas about a litigation and a strategy come to you in the middle of the night or at the most inopportune times when you're having a shower. Okay, literally, like when you're because during office I find that you're often going through motions. You're thinking and focusing on ensuring there's firefighting going on one matter, something has to be done, some deadline, and you're not really thinking of the larger picture of a litigation and what needs to be done and the strategy and end goal, etc. Sometimes matters need to be thought of and ideas will come to you. So you can never disassociate yourself from the matter. And you will find your mind playing, thinking about some matter, even when you're home, even when you're lying down ready to sleep. So you've just got to love it. If you don't love it, you're not going to be able to do well in this profession because you are never going to be able to disassociate and have that artificial line that now I'm home, I'm going to shut my laptop and not think of work. If you want a job of that nature, litigation is not for you. Okay, rethink your career choice very, very carefully if that's the way you want to do it. And it's a personal choice. If you enjoy it, hell, there's a thrill. You're in court. You're put into nuanced positions. You have to think on your feet. You have to react, and it's a very, very challenging profession to be in. So once I started, I really, really enjoyed what I did, and I think that's part of the reason why we've achieved what we've achieved, because you're enjoying the dream, and you're living. Yeah. That's what I would say to people. And yes, the man on the top of the mountain doesn't land there. He has to climb up. Okay. So you're always going to start at the bottom of the mountain and you have to make your way up to the top. Don't look at Harish Salve and say, I want to be a Harish Salve and then expect to be there in 2 years. Okay. It's not that simple. Harish has worked 40 years in the profession before he's reached there, and he's put in a hell of a lot of hard work. It's not that he gets to charge 25 lakhs per appearance or 50 lakhs per appearance for this 30 seconds in the Supreme Court, and everybody should not be illuded saying that that's what I want to do and that's how that it's not. Everyone doesn't make it. Okay, you have to be realistic, but you have to be willing to put in the effort to reach there, and that should be your aim and goal as well.
Thank you so much, sir, for sharing your wonderful journey. And I love the fact that even your metaphor, the man on the hill, is inspired from your life of hiking, and that will really stay with us. Uh, Anindya, if you could now share your views on the same on what is it, what are your views? Is there some feedback for the student community which you would like to give, or some experience which taught you something?
Ralsa and Peshwan already beautifully expounded what tips students should keep in mind. So I'll keep myself very brief. And from a personal experience, when I joined law school, it was back in 2006, and even until my 4th year, I was like, I'm going to be a banking lawyer. I'm going to make a lot of money. That's what I'm going to do. So all my internships were all banking. It was only by pure coincidence that one firm didn't have banking. They said, do you want to do litigation? I said, sure, let's do it. And I absolutely loved it. I never looked back. And this was between my 9th and 10th semesters. So this is just before you start and you join the profession. So why I'm giving this example is keep your mind open. Don't go in with blinkers. You may say, oh, I want to do this. But don't ignore the other things, because ultimately at the end, you may end up doing that and you may end up loving that. Like in the 9th semester and 10th semester, I did an internship coincidentally with Raj sir in the previous firm. And I absolutely love litigation. And that's what I've been doing since then. So that is what I would ask all students to keep in mind. Don't shut yourself off to other things. Keep an open mind.
In fact, just to add, if you don't mind, I find that if you want to do litigation, I would advise you to do an internship with corporates. I would advise you to do internships with different aspects of law. If there is a real estate lawyer and doing drafting of conveyances, etc., drafting of documentation, I think it's very, very important as a litigator to have a background as to how and what goes into the preparation of a document. As Raj mentioned, I initially was a corporate lawyer and I did a lot of transactional work as well. I find that today when I look at a share purchase agreement or an agreement and I look at the reps and warranties which are written, I am often able to think about what went into the drafting of that rep and why a rep has been worded in a particular way and not the normal way. And often I'm able to pick up on nuances which I would never have been able to do as a litigator had I not had the background as to how this is drafted and what goes into the drafting of the document. No experience is wasted, because ultimately, yes, you do. If you do real estate work and you know how to draft a conveyance and you know you've done due diligences, you looked at nuances, etc., some issues will come up when you are doing a litigation related to real estate. So you will learn and grasp, pick up knowledge. It's going to come in good stead to you as you grow and as you specialize in this profession. So just go out there and learn, learn, learn. You've got to have that fire in your belly to kind of keep eating it up and lapping it up.
Thank you so much, all the panelists. This has been a very encouraging and a motivational webinar, if I may say so. And thank you so much for your views. Thank you for joining us here today. With this, we move to the end of the session, and I would request Mr. Utkarsh to take it forward.
Utkarsh,
you're on mute.
You are on mute. You are on mute.
Yep. Yeah. So first, thanks, Sanjay. Awesome session. Thank you, Raj sir. Thank you, Peshwan sir. Thank you, Anindya, for all your insights. I think your experience matters. Anything coming out of you matters for students at any given level. To shape the career, to understand the subject, it's very important for the student specifically. Thank you all the viewers for joining. Now, the purposes of these sessions are, to give you a perspective on a subject, to give you a perspective on a practice area, and also to help you shape your career in that practice area if you plan to do so. So that is what our motive is. If you have any other suggestions, any other topics, any other feedback, do let us know. I'll be sharing a link on the chat section. Also, you'll be receiving a link. Please share with us. Thank you again for joining. Thank you all the speakers for sparing the time today. Thanks a lot. Thank you all. Thank you, sir.
Thank you, SkillxPro, for having us. Thank you, Pranjal, for the excellent moderation. Thank you
so much.
Thank you, Utkarsh. Thank you, Pranjal.
Thank you, sir.
It's been a pleasure to be here.
Same here. Bye-bye.
Thank
Bye,
you,
sir. Have a good day ahead.